Good last count, Corla, and I want to just start by commending Deputies O'Callaghan and Whitmore and their colleagues for bringing forward this important bill and to express the strong support of Labour for this bill. And I know as we stand here, all of our thoughts are with the people of Ukraine enduring horrific bombardment and the brutal Russian invasion. And I know others have pointed out that this bill also has an application for the many who are fleeing here to our shores seeking refuge and who may be at risk of exploitation by unscrupulous landlords. And I think we'd all be very conscious of that. I'm very glad the government is supporting the bill, but I would echo calls of others for a clear timeline as to its adoption and its introduction into law. And I know Minister McEntee in particular has expressed strong support for it, and I know that's why the Cabinet have agreed to approve it in principle. I think that's very important. I know all of us want to condemn the appalling practice that has been described and that this bill aims to criminalise. And indeed the bill would create two offences. First, the offence of a person accepting or requiring sex for the purpose of access to or retention of accommodation or related services. And secondly, an offence of facilitating the offence of requiring accepting sex as a condition of accommodation, notably aimed at publishers, and both are indictable offences carrying significant penalties. I want to come back maybe to the discussion about the offences, but I suppose first just to speak a little about the context and to say that we know that this practice, we know from Britain that this practice has been appallingly widespread, and UK research by Shelter finds between 30 and 40,000 women targeted by current or prospective landlords over a 3-month period. Here we don't have that level of data, and I know that would be, I think, important to know a little more about how widespread this appalling practice is. But we are all absolutely indebted to Anne Murphy and to the Examiner for their report on the practice and really for bringing it to our attention some months ago. And notably in their investigation, they were able to identify particular ads with language and with clear indications in the ads that that sex was being sought in return for rent. And what the Examiner investigation shows us is the need to address this practice specifically in legislation, and it also illustrates really one of the causes of this appalling practice, and that is of course the power imbalance, where there is just so little accommodation available for those seeking to rent, and where therefore landlords are in such a position of power relative to tenants currently in Ireland. And clearly there is always a power imbalance, but notably so in a housing crisis. And across the country, we're aware of this. We know from data how few properties are available for rental currently. It's one of the reasons we brought forward a renters' rights bill for Labour, drafted by my colleague Senator Rebecca Moynihan, to seek to try and strengthen renters' rights and to ensure that landlords would have more responsibilities there. But we also, of course, do need to see an increase in supply of housing, the building of housing on public land, and that's crucial to address this, the housing crisis, and I think we're all well aware of that. Just to speak a little about the provisions themselves in the bill, and clearly and about existing law, the Minister has identified some drafting issues in his speech and the need for the tightening up of language. But I think these are issues that could be dealt with clearly through collaboration with the bill's proposers at committee and report stage. And similarly, the issue of compatibility with existing criminal law could be addressed. And certainly there is a need to ensure we have a clearly streamlined series of laws on sex offences rather than sort of piecemeal amendments being carried out. In terms of civil law penalties, a sex for rent arrangement under housing law would clearly be in breach of implied covenants of quiet enjoyment and exclusive possession. But there is a gap because such covenants are only read into tenancy agreements and not into room for rent or room sharing arrangements. So that's clearly a gap. And of course the remedies for breach of tenancy covenants are civil only, and there's no criminal offence committed by a breach. Now I think Deputy O'Brien made a very, very good point about the need to ensure the Residential Tenancies Board would be able to take action against landlords, unscrupulous landlords who are engaging in this practice. So that is another matter that might be addressed through separate legislation. On the criminal law, as others have said, Part 4 of the Criminal Law Sexual Offences Act 2017 does criminalise the purchase of sexual services, essentially bringing in Nordic model laws into Ireland in keeping with the unanimous Justice Committee report, which all parties supported, and indeed had the widespread support of the trade union movement and NGOs NGOs, on women, the National Women's Council, the Immigrant Council of Ireland and others. So a big campaign was resulted in the passage of that important legislation that has been very effective in other countries where it's been introduced to tackle demand for sexual services and to reduce the incidence of prostitution. And that law was introduced precisely to deal with this issue of exploitation and abuse of power, recognising that women in particular are more liable, and women in particular from migrant backgrounds and disadvantaged backgrounds are very much at risk of exploitation and abuse, and that a law tackling demand by criminalising the purchase of sex is an effective means to deal with that exploitation. So that law is in place, but it doesn't cover the situation specifically of a person who seeks sex in return for renting them property, because that law tackles those who are engaged in the sex trade, engaged in prostitution and exploited through prostitution. So there is therefore a gap, and the purchase of sexual services ban wouldn't cover the practice that is being addressed here. Other potentially applicable offences under the Non-Fatal Offences Against the Person Act similarly would not necessarily cover this. The updated definition of consent that we fought very hard to get included in Section 48 of the 2017 Act, which is a hugely progressive definition, does provide that consent must be freely and voluntarily given, but it does not address the situation where consent is lacking by reason of situation of exploitation of power or economic dominance. So again, there's a gap, and that's why this legislation is important. And the second offence of arranging or facilitating, as the Minister has said, that may well be covered in any case under Section 7 of the Criminal Law Act 1997. But there is, I think, a strong case to be made for explicitly prohibiting advertising of ads of this sort. And we do have some precedent for that in Section 23 of the Criminal Justice Public Order Act of 1994. I just want to finish, Minister, by referring again to the context for this and the context by which we have a need for this legislation. As the tragic murder of Aisling Murphy reminded us, unfortunately and regrettably, women are still particularly vulnerable to harassment, to abuse, to intimidation and exploitation. And so this is not a new practice, the practice of sexual exploitation of women and indeed of vulnerable persons. And we know it's compounded by class, by immigration status, and we know that women from migrant backgrounds are particularly vulnerable to sexual exploitation in Ireland today, where we see large numbers of migrant women exploited through the sex trade on a daily basis. I think that it's very important that we recognise that power imbalance and that we recognise the coercive context in which practices like the practice identified in this legislation are being carried out. And finally, just to refer again to the appalling situation in Ukraine and to pay tribute to to international and national NGOs like the SERP Centre in UCD, the Sexual Exploitation Research Project, which has identified really strong risks of women and girls being vulnerable to sexual exploitation and trafficking where they are moving in such large numbers, fleeing from the Russian bombardment. We know that there's been incidences of that at the borders of Ukraine, and we know, of course, that there's also a risk that it will happen here, and indeed there's been some suggestions that it is already happening here. So all the more reason, therefore, Minister, to ensure this legislation is brought through the process speedily and that we see a clear time frame for its adoption. Gurmahaga.